Thank you so much for agreeing to do this with me. I'll give a quick intro of who you are. Then you can kind of give us a little bit more detail. So Nicole Warmerdam, local San Francisco Bay Area estate planning attorney, but you can probably do business and create estate plans anywhere in California.
Yeah, I have some roots in Southern California as well. And so I do have some clients in like Los Angeles and San Diego. These days, a lot of stuff is virtual. So if you're in California, absolutely, I can help you out.
And you also are my personal estate planning attorney and set up our trusts and all of that stuff. That was mostly pretty much virtual, except for one signing meeting. So yeah, if you want to just give a little bit of background about yourself.
So I've been doing this for about 16 years now. Started out in Southern California. Now I'm up here in Northern California. As you mentioned, Joe, I work with folks all over the state. I do what I call foundational planning for clients, which is getting that plan in place with all of the documents that everyone needs: trust, will, durable power of attorney, advanced healthcare directive, and some other what we call boots and suspenders type documents to make sure that, you and your estate and your loved ones are protected. In addition, I do administration. So anyone who puts together a plan, unfortunately, when, a loved one passes away, that plan needs to be administered. And so I help those family members and those friends kind of step up and figure out what they need to do in order to get an estate distributed and closed. So that's, basically what I do in a nutshell. I was really excited to talk to you and to your listeners about some things that come up in my practice that have to do with real estate and ownership of real estate in California in particular. A lot of clients have that primary residence, maybe a vacation home. I work with a lot of real estate investors. And so real estate is really front of mind. One of the most basic questions that comes up time and time again with folks has to do with owning real property in a trust. And that's really because when I'm doing an estate plan for clients, it tends to include a trust. And the reason why folks have a question about this is, and you will remember this, there's a little bit of homework after you sign your documents with a trust. And so that bit of homework is you have to transfer title of your assets into your trust. So the bank accounts, the real estate, all of that stuff. And so clients, generally are wondering, well, what does it mean if I own my property in a trust? And so where this comes up a lot is if they're buying a piece of property for the first time and they have a trust, or if they're selling a piece of property that they own in trust, or even refinancing a property. Rates have been great for a very long time. They're still great historically. Folks are still out there refinancing their properties that they've put into their trust. Again, when we create an estate plan, the first and foremost thing is get your real property into your trust. And so we'll do a grant deed. We'll record it. That means that Joe and Jane Smith, who owned the property, it's now Joe and Jane Smith as trustees of their trust. But say you don't own property yet. Say you've created your estate plan and you're looking to buy that first piece of property, or you're looking to buy a new piece of property. A lot of folks don't realize they don't have to buy it individually and then transfer it to their trust. They can actually buy it in the name of their trust. So again, instead of Joe and Jane Smith, it's Joe and Jane Smith as trustees of their trust. And it's important when you're starting the process that you kind of make everyone aware of this, including escrow and title, because they're probably going to ask you for some, additional documents. They'll want to look at the trust. They'll want a copy of the certification of trust, all of that good stuff. Now, it's no harm, no foul if you buy it in your name and then realize, whoops, I was supposed to put it into the trust. It's just by buying it directly in the trust, the client is going to save some time and some money. They don't have to go back and do that extra deed, which is, probably going to be on their dime. They're going to have to go to somebody like me or deed service and get that deed into the trust done. So it's a real quick way to just get it into your trust when you buy it. Similarly, as you know, Joe, when you sell a piece of real property that you own in trust, the seller isn't going to be Joe and Jane Smith. It's going to be Joe and Jane Smith as trustees of their trust. And so, again, there might be a little bit of extra paperwork, some disclosures and things related to the trust. But other than that, it's really the same process. There's no additional difficulties or complications about, buying or selling property in trust. And so that's, I know, a concern for a lot of people. So they're usually pretty relieved to hear that. One thing that does pop up as well has to do with refinancing. And this is probably something that, is more common with folks because this is something you might do several times over your lifetime. So you buy that forever house and, over the course of like 20 or 30 years or more, you're probably going to refinance a couple different times. Maybe there's a lower rate, for instance, or, you want to go from a 30-year to a 15-year, maybe pay out that house a little bit quicker. One of the biggest things that I just put on people's radar is if they're refinancing their home, oftentimes the process is that the house is taken out of trust, that refinance is processed, and then it's supposed to go back into the trust. So essentially the client ends up in the same place in terms of the title of their property. It's in the trust. We're going to avoid probate, which is why we put that trust together for them. But there can be instances where sometimes, unfortunately, it doesn't get back into the trust. So we process that refinance transaction and that grant deed doesn't get signed to put the property back into trust. And so I tell my clients, when you're thinking about refinancing, just keep in mind at the end of the process, you want to just confirm with escrow and title that they've put the house back into trust. Because again, that's something, that they can help you out with versus you having to do it later.
So why is that you have to, if you're doing a refinance, why you have to take it out of the trust and then put it back in?
There's a couple different reasons. One is I'm sure the legal department is not keen on having to go through and review all the terms of the trust. That's sort of my suspicion as a practitioner. But I think a lot of it has to do with the fact that generally speaking, when you're taking out the loan, you're taking it out as an individual. And then the trust is what we call an additional insured. And so because of that, they will generally take the property out of trust, do the refinance, individually, new loan in place in the individual names. And then of course, once you've done that, you can do whatever you want with the property, including putting it back into trust. And so I think that is the official answer there. So there is a method to the madness. It's not just something that, lenders are doing willy-nilly, but it's something to be aware of because most clients don't notice that happening in the background. They're just kind of signing the paperwork and, lo and behold, maybe it didn't get back in.
So maybe just a real quick, just in case people who aren't really super familiar with why to put something in a trust and avoiding probate, just, 30,000 foot level real quick. There's so much information out there on what to do this, but just for people who might be watching this, what is it, if you don't mind?
That is a great question, Joe. And that's kind of the foundation of this whole discussion thank you for bringing me back to that. So the reason why we have what I call that homework assignment, which is you signed your trust. Yes, you're done with your estate plan. Congratulations. The next step is to get things into your trust. And the reason for that is because, your trust, the terms of it are only going to control the property that it owns. And you've created the trust to avoid probate. Trusts are a vehicle that avoid probate. And so you want to get your property into it so that property is going to be distributed according to the terms of the trust, and it's not going to be subject to probate. So probate may be required if you have property outside of your trust. If you own it individually, a probate might be required. There are some other exceptions. Again, I don't want to get too much into it, but if you own property like in joint tenancy with another person, if you have an account with like a pay on death beneficiary, there are other ways to avoid probate. Trusts are great because it's a way to get all of your property sort of in one place and have a very streamlined plan. Trusts are great for avoiding probate. Wills are not. I'll just throw that in there. A lot of people do an estate plan. They have a will. They're like, great, I'm good to go. And yes, you do have an estate plan. You've put pen to paper and you've got your goals, there and your distribution scheme in place. But unfortunately, wills don't avoid probate. And so that's why you see trusts in almost every estate plan.
And I'll quickly summarize. It's when you die, all your assets and everything, you want it to go to, whatever, beneficiaries, kids, charities, friends, whatever. If you have a certain amount of assets, then it would go through the probate process, which is lengthy, expensive. A lot of people, attorney's fees and other things and a court and all that kind of stuff. Whereas trust is a little bit more automatic. So it's a little bit more expensive, before you pass away to do this, but it's a lot cheaper and a lot less headache for your loved ones or whoever is going to end up with whatever's left of your assets at that point. I do a lot of probate sales, a lot of properties that are in probate. I list those and in trusts as well. And I see people as recently as like last year who, passed away a few months ago, and they've updated their will. And it's a very updated, detailed will. So that couldn't have cost less than $1,000 to do that. Do a trust, which would have cost probably less than $5,000, but their beneficiaries are going to pay $30,000, $40,000, $50,000, $60,000 or more in legal fees and have to wait a year and a half for probate to close, assuming there's no issues. So the question I have is, why would somebody have done that last year? Why would that attorney be like, why are you doing this? Let's do this instead. Like, what is the reasoning behind why would somebody?
Yeah. As you're mentioning that scenario, I'm like, yep. It's checking all the boxes, unfortunately, because I run into that situation as well. The saddest thing really is today to do an estate plan with a will or a trust, in each case, you have to have all the details of what you want to happen in the document. And so in most cases, it costs exactly the same to do an estate plan with a will or a trust. That's kind of where we're at these days. Used to be wills were cheaper. They're really not now. The fact is I have had some clients over time that did not want to do that homework that I talked about. They did not want to put their property into the trust, go to the bank, do the bank accounts and whatnot. And it's really unfortunate because a lot of people have financial advisors or CPAs or estate planning attorneys that can help them with pieces of it and can definitely instruct them on what they need to do for the rest of it. It's really kind of a one and done thing in terms of, here are my assets. Here's what I need to do, get it done. Great. So it is kind of unfortunate that sometimes that is the hurdle that people just can't quite get over. And so because of that, like you said, exactly, a lot of wasted time, a whole lot of expenses they would not have had to pay, and just a lot of stress for their family members and their beneficiaries. So that it's really sad when you see that. Another one of the areas where I have clients coming to me and asking me questions about, owning real estate and how they should own real estate really revolves around how to take title to their real estate. And if you're an individual, it's fairly simple. When you're contemplating owning real estate with somebody else, that's where it gets a little bit more complicated. And I think that's where most of the questions are. So it's really going to depend the different options that you have to hold title with another person on whether or not you are married and domestic partnered with them or whether or not, you aren't. And so, for instance, if you have two individuals that aren't married, they aren't domestic partnered, they may or may not be related at all, but they want to own a piece of property together. There are different options to do that. And I think it's important for people to think about that before, they sign on the dotted line and purchase that property together, because the way that you hold title has ramifications in terms of, if one of the co-owners passes away, there can be some income tax ramifications as well. If you're going into the transaction at the 11th hour, escrow asks you how you guys want to hold title, that's probably not the time to be thinking about it. It's beforehand, so you can make an educated decision. So for instance, if you had like two friends who wanted to buy some investment property together, one of the ways that they can hold title is as tenants in common. And that is something that you see fairly common. And tenants in common is great for a couple of reasons. If you have two people that are coming into something together and maybe one is putting a little bit more money in than the other, you can actually have co-owners that own the property in different percentages. So if you have two owners, it doesn't have to be 50-50 necessarily. So there's some flexibility with tenants in common. One thing to be aware of, though, is if you purchase a property with that, that friend, that investment property, and you own it as tenants in common, if one of you passes away and you own it individually as tenants in common, then that piece, 50%, 25%, whatever it may be, that piece is going to go through probate. And what happens is that piece is then distributed to, whomever is listed in the estate plan or whatever heirs there may be. And so what you end up is that property that you co-owned with a friend, you may now be co-owning with strangers. And so that's something to be aware of as well. If you're the co-owner that passed away, that's probably great. You want the property to go to your, friends or your family members, but it's just something to be aware of if you're the surviving co-owner.
A little side note on that, because TICs, as they're affectionately called in San Francisco, are a thing, right? A very common thing in San Francisco, not necessarily super common everywhere else.
Yeah.
As like an ownership structure, keeping in mind that if you bought a property with a friend, let's say a duplex, instead of you each buying a single family home for 1.5 million range, you guys can buy a duplex where you each have the same amount of living space essentially for $2 million. And so much cheaper and a great way to be able to live in the neighborhood you want to live in, have the house you want to have for a much lower price, and still be able to, have your asset grow and things like that. So a lot of people will do that. Now, let's say the unexpected occurs and one of the friends suddenly, surprisingly, somehow passes away. If they have a loan that they're both on, one loan, that could cause, financial struggles for the surviving friend, because if their mortgage is, mortgage, property tax, insurance, everything is $10,000 a month, they're splitting it. One person passes away, they're both on the loan. So you can't just say, well, I'm still paying my half. Well, the bank says, yeah, that's not how this works, right? You have to pay the whole amount.
Right.
So, that could create a lot of complications. So I've done videos also with, TIC attorney Andrew Sirkin, who kind of goes over that. And also I need to do a video with a TIC lender as well to go over how that whole thing works and everything, keeping in mind that if you do this kind of structure, that you may want to look into TIC loans, which not a lot of banks do, but enough in the San Francisco Bay Area do, because they're familiar with this concept, fractional ownership loans, that could potentially offset those issues, that risk of something like that happening.
And that is a really great point, particularly in San Francisco, also a little bit in Southern California. That is a very common and very understandable scheme for folks trying to get into real property and, the affordability issues that they face in doing so. So those loans are a great option to sort of protect yourself if this is a structure that you're interested in doing. Now, similarly, two co-owners can own something as tenants in common. And this is a different type of scenario. It's got different ramifications. Tenants in common only works, however, if you have two individuals that want to own the property 50-50 or, 25-25-25-25. It has to be equal co-ownership, essentially. What can be nice about joint tenancy, again, everybody's circumstances are a little bit different, is that with this structure, if one of the joint tenants passes away, then the other joint tenants automatically inherit that interest. So if there's one remaining joint tenant, they have 100% interest. If you have, say, 4 joint tenants and one passes away, then that 25% interest is sprinkled equally among the rest of them. And this structure avoids probate. So again, it's not for everyone, but in cases where, maybe we've got family members and they're all co-owners, and so they want that property to go to the other co-owners when they pass away without probate, that might be a good structure for them. Maybe not necessarily for those two friends who were investing, they want to make sure their property, stays in their own estate and doesn't automatically go to the other. But it's an option that's good for some people.
That sounds like maybe, two siblings that don't have partners or kids, or, they have all the same beneficiaries, the same parents, the same cousins, aunts, uncles, friends, everything. And they say, yeah, this is cool. Like, something, because we're, maybe just, this is our first place and we'll buy more. And then when we get married and do these things, we can switch it up. But for now, if something unexpectedly happens to me, I just trust that you'll do the right thing. That sounds like a much more rare thing that people would agree to, but probably still exists.
Yeah, it does. And I see it mostly, again, like you said, with the family member situation. And it is usually for folks that haven't done estate planning. So it's where, nobody's set up a trust or a plan and they know they want to avoid probate. And so they kind of all come to the consensus, hey, let's do this titling. And then that way, we're going to avoid probate and it's going to stay in the family, which kind of leads me to my next point, which is, if you're co-owning property property and you're an individual, you can actually own your piece in your trust. So if you're an individual, you went and you set up an estate plan, the person that you're in business with, your friend, they've also gone and done that. So yay for estate planning, but they can actually co-own the property in their individual trusts, either as tenants in common or joint tenants, believe it or not. That is a great way to avoid probate, but also, like I said, the benefit of the trust is sort of streamline distribution of your estate. And so, not only do you avoid probate, but you ensure that that property as a part of your estate is going to go exactly where you want it to go in a very streamlined and cost-effective way.
Yeah, especially because oftentimes people have more than just the asset of their home. They have retirement accounts and, restricted stock options. I don't know if that passes through, and, bank accounts and cars and whatever else. Right. So the more that they can put in their trust in the unexpected event of something happening, they're just protecting their loved ones and, friends, family, charities they want to donate to, whatever, from having to spend money on those pesky attorney's fees.
And believe it or not, we don't want people to have to spend attorney's fees that they don't have to spend. It's kind of heartbreaking, when you tell somebody, hey, we could have done this in 3 or 4 months for a couple $1,000, but we're going to go to probate court and it's going to be 18 months and maybe like $25,000. It's unfortunate. Now that we're kind of chatting about this, we've been talking a lot about, two sort of unrelated or at least unmarried individuals owning property together. When it comes to titling property where you are married or you are domestic partner, titling is going to be similar, but a little bit different. So if you'd like, I can kind of go into that a little bit.
Yes, please, yeah.
So, obviously when you get married, you don't cease to be an individual. So, many of us come into the marriage and we've got some property already, which would be called separate property versus property of the marriage, which is community property. And these distinctions are important for a couple different reasons. But for our purposes, if you've come into the marriage and you've got some existing property, which is separate property, that's going to be dealt with a little bit differently. So, you can own that, individually as your, a married individual as your sole and separate property. You may have a separate property trust. Later in life marriages, people may have a lot of property. Maybe they decide to say, I do, but that doesn't mean they want to commingle everything. So they could own that piece of property individually in their own trust. But what often happens, what, I see kind of day in and day out is, folks are coming to me, they either have none or very little separate property, they're getting married, and they really want to create a joint estate. And so they're going to do a joint trust. And so in that case, what happens is, you may have Joe and Jane Smith. We're creating the Joe and Jane Smith Trust. And so as I, mentioned kind of earlier, what they would do is they would actually transfer title to Joe and Jane Smith as trustee of their trust. And so when you have a married couple, oftentimes you're going to see that property in their joint trust if they've got an estate plan. Which hopefully they do at some point. If they don't have an estate plan, then their options are somewhat similar to those unmarried individuals. They can own stuff as joint tenants. If they want to own it equally and avoid probate. Again, you see this a lot with folks that haven't put together an estate plan, and this is a way to avoid probate. It's what I call informal planning. But if they want to own the property together and they don't want to do joint tenancy, and there's some tax reasons why they might not want to own it in joint tenancy, then they can own it as what we call community property. There is no sort of tenant in common titling for married individuals. It's known as community property. And it's also the same, I should say, for folks that are domestic partnered. In California, for these purposes, they are treated exactly the same as a married couple. So there's the community property titling that they can take. That in and of itself doesn't avoid probate. And so California got really creative and they came up with community property with right of survivorship. The reason why they did that was for income tax reasons. So as I mentioned, joint tenancy with a married couple can have some not so great tax consequences. What happens is when each individual passes away, their estate can get a step up in income tax basis. if they have their assets owned in community properties. So that's important because, over time with the community estate, those assets are going to increase in value. So when the first spouse passes away, even though they've purchased that property years and years and years ago, and its income tax basis is really low, it's going to get a brand new income tax basis as of the date of death of the first spouse. And then when the second spouse dies, it's going to get another new income tax base, meaning that when it's sold years and years and years down the line and we're calculating gain, we're going to look at that high second step up in income tax basis and compare that to fair market value. So that means, there's going to be little to no taxes due. So that's with community property. And the reason why California jumped in and did community property with right of survivorship is people really wanted that great income tax benefit, but they wanted to avoid probate too. And joint tenancy avoids probate, but you don't get both of those step ups in income tax basis. You only get one. And so people were torn between, I want to avoid probate, but I want all those great income tax benefits. And so the California community property with right of survivorship sprung into being, and it has the benefit of both joint tenancy and community property. You get two steps up in the income tax basis, but you also have the right of survivorship. So we're seeing this a lot more now that this has kind of been on the books for several years. We're seeing a lot of people with this community property with right of survivorship, which is, I think, the right way to own property as a married couple if you don't have a trust.
I see. Most married couples who buy properties, that's what they choose. The escrow officers send them the kind of description of each thing and say, here, decide, choose. They do some Q&A. They think about it a little bit. Yeah. And then usually they'll ask me and I'll say, I see that everybody does this, and then that's what usually they will choose.
So the good news is that is catching on. We're seeing that a lot more often. And then again, of course, the goal as the estate planner, I have to put my estate planning 2 cents in. The goal is hopefully, if they don't already have a trust, a joint plan together, that's something that they're contemplating. And then of course they can transfer that property into the trust and it will have other benefits as well for them.
We went over everything in detail. We answered questions and, it's probably going to be boring to 99% of people, 99.9, but right. That 0.1% who's like looking at this stuff is going to say, this is helpful. And like with a pen and paper and like, oh my God, whatever, whether they call us or not, it's just like great, valuable content.